The opening legal argument immediately reveals the real battle. This is not simply about someone remaining in a house. It is about deciding which legal framework controls the dispute. The property owner keeps the issue narrow by emphasizing ownership, revoked permission, and the absence of rent. That strategy avoids creating obligations that normally come with a landlord-tenant relationship.
If there was a verbal lease agreement, would this more properly be an unlawful detainer instead of an ejectment?
If the court finds that there is a verbal agreement for occupancy of the property, then yes, the RLTA would apply. So if Ms. Crable is, gonna assert on the record that she's a tenant, then we can proceed with a notice under the RLTA. But my client's position is that the RLTA doesn't apply because there was no such agreement.
Okay. Thank you. All right, so Ms. Craybill, it is true the documents that you supplied are not penalty of perjury documents, but here to show cause, you are able to tell me what you would like me to know. So I'm going to swear you in. Can you raise your right hand, please?
Absolutely.
Do you swear and affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
So help me God.
Okay. You can put your hand down. And your name is Faith Craybill, is that correct?
Yes, Your Honor.
Okay. What would you like me to know?
Firstly, that I and Mr. Crable have been through so much. Like I said, he's my father-in-law. My 4 children live in the home. It's the only home that they've ever known. I have cleaned, cooked, taken care of everything within the home, which does in fact pay for rent in the living portion of things. I'm not saying that I'm a quote unquote tenant because there was never an agreement that was made other than the verbal agreement that he gave me that as long as I was looking, that I had the security of knowing that my children were not going to be homeless. He then goes to my husband, not me, breaking this verbal agreement, and tells Brandon, my husband, that he is going to file against us in the court without even giving me a chance to defend myself or our children. And so here we are today. I entered that verbal agreement with him. I've done everything within the program and my counseling that I was supposed to do. I have done everything that I was supposed to be doing at the home. Like I said, I'm the primary caregiver of 4 children, all with disabilities. I have letters from their pediatrician here with me. I have letters from my doctor. I have my medicine records with my insulin and things, all stating that we are not able to just up and leave this home without securing stable housing first. I have been working very hard with my program and with my counselor, and I just did what the pediatrician has a group of lists. I just got listings from them. I have those listings I just received. Like I said, I am doing everything that I need to do to try to secure housing. I've had 4 different leases now that I could have applied for, but as soon as they heard that this was pending, they said, don't bother and keep your money.
Well,
Nobody
let me
wants.
let me ask you this. So at show cause, really what I'm looking for is whether I think it's clear that the other side's entitled to what they're asking for, if there are any issues of fact that we need to dig deeper on. So you've said a couple things that I want to kind of hone in on. You're telling me that you think there was a verbal agreement that you could stay in the house so long as you did certain things, correct?
Yes, Your Honor, there was a verbal agreement.
When did you enter that verbal agreement?
As of give me one moment. I apologize. Is there a date on this? I apologize. Like I said, I have lots of documentation. I didn't know that we weren't allowed in the courtroom. April 27th is when I went and got the application stuff for the chart property. So it would have been roughly a week or 2 before that.
April 27th of this year? Of
this year, yes. And I've been trying to secure stable housing since January of 2026. When he initially said that our time was running out, basically no set time for us to leave, just threats and a lot of trauma responses for me and my children.
Hold on. Yep. I'm going back to the facts here a little bit. So when did you move into the property?
We have lived there since before I had my twins, so 2022. I would say easily May, June, probably July of 2022. It's the only home my children have ever known.
And so when you lived there in 2022, 2023, 2024, 2025, what allowed you to live there through that time period? Was there an agreement? Were you paying?
It was more of I cook, I clean, I take care of the children, and we can stay there and try to get on our feet. I have been on TANF. Like I said, I have 4 children under 4, all of which include pregnancies, postpartum, all the things that happen. I've received mental and medical help throughout all of my pregnancies. I've always kept up with everything that I'm supposed to do to show him probable cause and good cause that I am grateful for living in his home. I mean, he's my father-in-law. He signed the paper when my husband and I got married.
So the verbal agreement, you're not saying that was back in 2022. You're
No,
saying
I'm
April.
stating within the last 6 months, we were having difficulties because of all the stress of my husband and jobs, etc. And so he said, hey, you guys need to find your own place. I think it'd be good for you. And we agreed. And that was the end of it. It wasn't until recent, like I said, a little before April 27th, that he basically, he was like, hey, this is taking forever. And I was like, well, I don't want to be at risk at losing our place. And he's like, as long as you're looking for housing and can prove to me and communicate that with me, then we're good. And I've done so.
And that's where you submitted the letter from one of your service providers kind of acknowledging that
Yes.
agreement.
It's in their actual records. They do monthly check-ins basically of what's going on in my life and how they can help me. And that was, as soon as that was said, the day of, it was in there, because I was very on top of making sure that I'm doing what I'm supposed to. I have ADHD, so I have to have reminders.
Okay. All right, here's what I'm going to do. I don't know that I can decide this at a show cause. I think there is some.
Faith approaches the hearing from a completely different direction than the court. Instead of building a legal foundation first, she builds a human story. Every explanation centers on caregiving, disabilities, medical treatment, and the effort she says she invested in maintaining the household.
What's not answered for me is whether there is some sort of tenancy that's been established. If there is, then you would be entitled to potential representation through Northwest Justice Project. So what I'd like to do, hold on. Were you going to say something about that, ma'am?
Yes, if I may, Your Honor. Honestly, I just want to be able to secure the home for my children. I am actively looking for housing. I have the HS.
Hold on. Yeah, no. So I thought you were going to respond to something I was saying about Northwest Justice Project. So here's what I'm going to do. I'm going to actually put this case onto our unlawful detainer docket. I'm not going to ask the plaintiff to refile as an unlawful detainer at this point. But I'm going to put it onto our Friday at 10:30 docket.
Is that this Friday, Your Honor?
Ms. Kazmaier, when would you be available? I would like to do next Friday because I'm going to give the number for the eviction defense screening line to see if she does qualify for their services. So I would be looking at, oh, we can't do that.
Your Honor, I don't know
Ma'am.
if it may.
Ms. Crable, hold on. It can't be the 19th. The courthouse is closed. So it'd have to be the 26th, which I know is probably not ideal, but that would be the first Friday docket I have. Unless you want me to put it back onto the 17th, but I could put her back on civil docket at 2 o'clock, but I would be giving her the eviction defense screening line number.
I would prefer that, Your Honor. Just because if the court determines there's a tenancy, we'd like to get a notice out. So
yeah. Okay, so ma'am, because of a closure on June 19th, I'm going to have you come back on docket next Wednesday at 2 o'clock, June 17th. I
Okay.
do want to give you a number to call for eviction defense screening line to see if you qualify for their services. I'm going to get that number for you. Do you have something to write with?
Yes, ma'am. Yes, Your Honor.
Okay. Just a second, I'm pulling it up. Okay. It is 855 657 8387.
Okay.
Okay, so it can take some time for them to screen you. So I would strongly encourage you to call today when you get done in court here. Okay.
Yes, Your Honor.
Okay. And then I'll have the parties back next Wednesday, the 17th at 2 o'clock.
Okay, thank you so much. I appreciate it.
All right, number 11, 262-48308, Robert Craybill v. Faith Craybill.
Margaret Casmar, Your Honor, on behalf of the plaintiff, and I do believe defendant is here.
And Ms. Craybill, you're there.
Yes, Your Honor.
And I know last time this case was in front of me, but I'm just going to repeat myself. I do believe that Robert Craybill was a former client of mine, obviously not for this type of matter, for something wholly unrelated. And so I don't believe that I've obtained any confidential information that could be used to the disadvantage of either party throughout that. We had this discussion on the record previously, and I recall that both parties were fine proceeding, but I do want to address that again and just make sure first, specifically for you, Ms. Faith Craybill, that you are okay proceeding. And if you are not, that is okay too, and we can get you a new judge.
No, I said previously, I believe that you will give the order and what you believe to be true.
And Ms. Kassmeyer, any concerns for you or your client if I proceed today?
No concerns, Your Honor.
Okay. All right. I did look back. I know you were in front of Judge Scudder, and I had kind of questioned whether there was the perhaps ability for eviction defense screening line to be involved. It looks like that's not the case, but why don't the parties fill me in on where we're at?
So, Your Honor, obviously the first time we were in front of you on the 10th, we set it over for her to contact Northwest Justice Project. I was gone on the 17th, so it was set over to the 24th. At that hearing, I believe that was last week, she'd indicated that she was going to make an accommodation request. I objected, as that doesn't provide evidence of a tenancy, which is kind of the issue that we're dealing with here. Judge Scudder set it over a week for her to file whatever she was going to file with the court, or for an attorney to file a notice of appearance. We don't have any notice of appearance filed. We actually have nothing filed since her original response. I received today to my office an accommodation request. It doesn't have any additional information that hasn't been presented to the court, and to my knowledge, it's not filed with the court. Ms. Craybill may correct that if I'm wrong.
I don't know if it got filed. I have a bench copy. I can't.
I got it. I got it turned in this morning, and then they had me take it down for you to have the bench copy today as well. And I took the copy to her office last night, and she just was not there.
Okay. Go ahead, Ms. Kassmeyer.
So my position, based on her response that's already filed and these new documents we received yesterday, that she's not established any evidence of a tenancy. This is an ejectment action. We're here on a show cause why a writ of ejectment should not issue. It's her burden to show that there's a tenancy. She's made a claim that there's a verbal agreement, and she's provided.
Rather than rushing toward an immediate ruling, the judge deliberately slows the process. That decision is not hesitation, it is risk management. If there is even a possibility that tenancy rights exist, denying someone access to legal assistance too quickly could create unnecessary appellate issues later.
Letters from her, I believe, counselors. They're not under penalty of perjury. They don't provide any evidence of any verbal agreement between her and Mr. Craybill. Mr. Craybill filed a declaration that there was no verbal agreement. And so, I mean, at this point, we're a month beyond the first hearing, which is a month beyond when this case was filed. She's provided no showing to the court that she is a tenant. She has had 4 weeks now to obtain counsel. They've not appeared, so we're asking that the court issue the writ today.
Are you taking any position on the ADA request?
The ADA request is tenancy relate. I mean, if she was a tenant and she made an accommodation request, obviously that's, you know, something to consider. That's not really the issue we're here addressing. If she has to show that she is a tenant, and we don't believe she's made that showing, and we don't believe she is a tenant.
Okay, thank you. Ms. Crable, did you reach out to eviction defense screening line?
Yes, I did. I spoke with Chasington, and he said that because of the labor for rent and because there was no actual rent given to the plaintiff, that I didn't fall under their legal aid. However, he did in fact write up the reasonable accommodation request for me and assisted me with that and let me know what I needed to do to prove to the court, which was collect the letter that is in the document provided from my counselor, from the new life people that I work with, the medical letter from the pediatrician, and from my counselor showing that it is in fact dangerously and will impact my children's physical and mental disabilities as well as my own for being ejected. We are residents here. I've lived here for years. I have withheld my part of our verbal agreement. There's 2 different documents stating that the verbal agreement existed due to third-party hearing or communication, because I followed the New Life program for housing assistance, and I go to counseling regularly for my own mental health. I take medication. I did not include my medication list. I do have it present, but I figured that if you saw that you needed more information to prove said disabilities, I am more than capable of doing that. And if they refuse to go ahead with the reasonable accommodation request because I have been a tenant for so long, I will be filing discrimination, because that is what the attorney that I spoke with said was best for my children to obtain and keep their stability for their physical well-being.
So it sounds like there is one finding I can make at this point, which it appears now we all agree that there was not a landlord-tenant relationship. Are you in agreement with that, Ms. Craybill?
Yes, we've always been family. When he made this verbal agreement with me, that was the first sign of any kind of agreement. I took it with good faith. I withheld every part of that. I've tried to prove through documentation through the programs that I work with.
Okay, so that's okay. I just want to make sure we're all on the same page there. That's kind of step 1. So then step 2, and maybe Ms. Kasemeyer, you want to answer this. How should the court view an ADA request? I know if we were in a tenancy, it does impact the court's analysis, but how does it impact the court analysis, if at all, in an ejectment action?
That's a great question, Your Honor. I don't know that it does. I don't have any case law for you. I didn't brief that, but you know, certainly if this is a court of equity, if Your Honor wanted to, you know, stay the writ for 2 weeks, 30 days, something like that, to provide an equitable consideration for that. I don't know that there's any case law supporting that. You know, if this were a tenancy as a landlord, I'm required to provide accommodations, but this is a situation where permission was given, that permission's been revoked. I think the law on that is pretty straightforward. I don't think that even comes into play here. But again, you sit in equity, so I'll defer to the court.
Ms. Faith Crable, how much time do you think you need to find a new place?
I've currently been looking since January with the New Life program. I've listed what benefits I have available to me through the HRSN funding that's still available. With this reasonable accommodation request, it also brings that when I'm looking for new tenancy or new housing, I am not going to have a negative impact on my future of getting a place secured for my children, but a neutral one, as well as that. I like I said, I've been working so hard with the program. I have 4 different
Yeah,
applications.
so hold, just slow down real quick. I just need to know how much time you're asking for under your reasonable accommodation request.
I simply asked until I could find stability and housing for my children elsewhere.
So if you're asking me to make an order in equity to find that because of the reasonable accommodation request and noted disabilities that you need additional time to find a place for you and the children, I can't leave that open-ended. So
I understand that, Your
what
Honor.
what are you asking for? How much time are you asking for?
Like I said, I've been working since January. I have a couple of places I have already signed up and I have applications for right now. That I'm filing with New Life through their funding to try to get into these places. Like I said, it's really been difficult with this eviction thing pending. They always hear it and they immediately say, okay, we'll have a bad reference from the tenant. So obviously we're not interested. It's been very hard, with my mental.
Okay, so how much time?
Your Honor, I honestly can't give you a designated time. I would appreciate as much time as possible just so that I don't have that stressful situation. I apologize for speaking fast. I'm trying to like breathe. I do have anxiety and ADHD and stuff, so it's hard for me to focus at times.
One of the judge's strongest moments comes from demanding a specific answer to a simple question: how much additional time is actually being requested? Open-ended requests rarely succeed because courts cannot enforce indefinite solutions. Every attempt to return to broader personal struggles avoids answering the one issue that requires precision.
But I am doing the best that I can. I work, like I said, with New Life. You can see the multiple letters that they've vouched for me, that I'm working through their program. I don't know what a reasonable amount of time to ask for is. I never thought that it would come to this, being that we're family. He signed off as a witness for my marriage. I genuinely, like, I don't know what to ask. I don't know what's considered to be
Okay.
a fair amount of time.
Yeah, this has been going on for quite some time now, filed May 11th, so there's already been almost 2 months. So what I'm going to do, a couple things. I am finding at this show cause hearing that the plaintiff is entitled to possession of the property, that defendant has no interest in the property, and that the defendant is currently occupying the property without permission of the plaintiff. So I will sign an order for ejectment. However, I am going to stay it for 30 days until August 1st. I'm doing that in an equity position, given the reasonable accommodation request with some medical documentation that was filed today. And essentially what that means is it's about a 3-month time frame that's being given to move from the time that you were notified that the permission to stay at the property was being extinguished.
Your Honor.
So that'll be my ruling today. Yes, Ms. Craybill.
I was never given a time to leave this residence. I was never given a proper due process for eviction or any sort of ejectment.
Okay, so I am giving that today through the order of ejectment, and it will, after August 1st, if you have not left, then the plaintiff can have you ejected through the sheriff's office.
Your Honor, I don't have a place.
I'm giving you 30 days, ma'am.
I can't guarantee 30 days I'll have a place for my children.
I understand. Ma'am, I'm doing the best I can to balance homeowner's right to peaceful enjoyment of property they hold title to, and you, who has given me documents that suggest you need a little additional time before being ejected. So I'm balancing those weights. Okay. So that'll be my ruling. Ms. Kazmaier, if you have an order that you could create and submit ex parte, granting but holding until August 1st.
Yes, I'll get that circulated to Your Honor.
Okay, Ms. Craybill, you got this, okay? You can find a place. It looks like from what you've submitted to me, you have lots of resources. You have people helping you. Please reach out to them, okay? Okay.
Your Honor, if per se, let's say I can't find a place as of August, I apologize. I don't mean to be emotional.
It's fine.
If I can't, like I said, I'm working to the best that I can in my ability to do so. If I can't find a place for my children with this in place,
Mhm.
if he is not willing to give more time, am I going to come back and I can ask for more time? I have to ask these things because I have 4 children under 4
I understand.
depending on me to keep them
Ma'am,
stable.
ma'am, but you've been asked since either February informally or May formally through court proceedings that you needed to leave the house, that you're no longer welcome there. So I'm not going to give you further advice beyond that. I am going to go ahead and end the hearing. If you need to seek further legal advice, you can call back Northwest Justice Project, or legal aid. They may be able to assist you on how you would move forward if you don't have a place by the 1st, okay? Okay. All right.
The final ruling reflects judicial balancing rather than complete victory for either side. The property owner receives confirmation that possession legally belongs to him, preserving fundamental ownership rights. At the same time, enforcement is temporarily delayed because the judge finds enough equitable reasons to avoid immediate removal. That compromise illustrates how courts separate legal entitlement from practical implementation. The defendant loses the core legal dispute but gains limited additional time because of documented personal circumstances. Equity does not erase ownership, yet ownership does not always require instant enforcement. The decision demonstrates that compassion can influence scheduling without changing the legal conclusion itself. It is a carefully measured outcome designed to minimize unnecessary harm while still respecting established property rights. Even after receiving 30 extra days, Faith immediately explores whether another extension might be available. That question reveals why the judge becomes noticeably firmer near the end of the hearing. Courts generally expect litigation to move toward resolution rather than continuously generate new deadlines. The judge reminds her that notice to leave did not begin with today's order. Months had already passed before reaching this stage. That history matters because equity becomes harder to justify when substantial opportunities have already been provided. At some point, fairness toward one party begins creating unfairness toward the other. The hearing ultimately reaches that threshold, making a definitive end date necessary despite the difficult circumstances presented throughout the case. The broader lesson extends far beyond this family's conflict. Courts can acknowledge hardship without allowing hardship to permanently override ownership rights. Long-term informal living arrangements often create emotional expectations that feel permanent, but those expectations do not automatically become legally enforceable. This case also demonstrates why relying on verbal understandings inside families can eventually produce serious disputes when circumstances change. Clear agreements, defined timelines, and documented expectations protect everyone involved long before conflict reaches a courtroom. By the end, the judge's message is unmistakable. The legal system can offer time, guidance, and procedural fairness, but it cannot indefinitely postpone a property owner's right to regain possession once no recognized legal basis for continued occupancy remains.